Hi everybody, welcome to our webinar. My name is Chloe. I work in our marketing department at 360 Accountants. I'm joined by my colleague Sean Maloney, and we've also got our guest today, which is Lindsey Rhodes from Solicitors. I'll pass you over to Sean first to introduce himself.
Good afternoon, everyone. Good afternoon, everybody. My name is Sean Maloney, as Chloe said. I'm the Associate Director at 360. I guess my background is that I deal with a number of clients, both on a funding side, on also tax planning. So in terms of wills, I kind of look after a bit of the work that we have at 360 when we're talking about what's the taxable elements of wills and what can you do to maybe minimise some of the tax.
Thank you, Lindsey.
Hi everybody, I'm Lindsey Rhodes and I'm from Solicitors, and I head up the private client team. So I predominantly do things like wills, powers of attorney, estate planning, and then on the other side of things, so probate when obviously somebody passes away, and also trust work as well. So that's generally the gist of it.
Perfect, thank you. So before we start, we have had a bit of a break through the summer. This is our first one back. So bear with us if we go wrong. We're going to be talking about wills and lasting powers of attorney. It is getting recorded and it will get uploaded to our YouTube channel, which is 360 TV, tomorrow, and you will be sent a recording of it as well on an email tomorrow. So I will, before I start, if you've got any questions, pop them in the chat box or the Q&A box. And I will pass it on to Lindsey and Sean, and at the end there will be some time to ask any questions as well that you may have, forgot about or whatever. But yeah, I'll pass you over to Lindsey, who's going to start us off. I'm hoping Brilliant. You can all see my screen. Oh.
Yeah, that's brilliant. Yeah, so first of all, I just want to run you through the basics of wills and just a few issues that arise when we're speaking to clients who come in to speak to us about wills, different topics that come up, different things that people need to think about when they are considering putting a will in place. Yes, just want to go to the next slide, please, Chloe. Yep, so for anybody who doesn't know, I'm sure you all do, a will is a document that you put in place to outline a number of things, but specifically really how you want your estate to be dealt with on your death. Next slide, please, Chloe. So why do people need a will? People don't often realise that if you don't have a will in place, you die what's called intestate. So that means that your estate passes in accordance with a very strict and specific set of rules. And who received the estate very much depends on who's alive when you pass away. So whether you have a spouse or children or parents, it's a set of guidance which stipulates who's to receive what and when. They're not ideal for a number of reasons, specifically, for example, if you've got cohabiting couples, they're not entitled to anything from the estate. Spouses are only entitled to a certain proportion of the estate. The rest gets split between them and children. So again, not the ideal situation. And in default of spouses and children, it can go to parents, it can go to siblings, and depending on what your family circumstances are, a lot of people aren't necessarily comfortable with that situation. So putting a will in place basically negates any problems that can come up under the intestacy rules. Next slide, please. So what if somebody doesn't have any assets? I mean, a lot of people have this misconception that, if they don't have a house, why do they need a will? If they haven't got much money in the bank, why do I need a will? We generally say a rule of thumb is everybody has some kind of an issue in their life where a will really deal with things. So most people have things like jewellery, they might want to pass that on to a specific family member. It really doesn't matter how much money you've got, what your assets are, at the end of the day, it has to pass to somebody, and putting it down in a will just make sure that the people who you want to be dealing with things are appointed, and the people obviously who you want to receive the estate are going to get it. So that's why it's so important. It doesn't matter what your circumstances are, what your finances are, they're so important for everybody despite whatever your walk of life is. Next slide, please. So what kind of things can you address in a will? I mean, these are kind of the bog standard, I would say, clauses that most people tend to put in the wills. So your first one is your executors. So that is the legal role of somebody who deals with your estate when you pass away. And that really can be anybody. As long as they're over 18, they can be appointed. We see a kind of mixed bag with what people put as their executors. Some people put their spouses, the children. That tends to be the most normal kind of appointment. But some people, they put professionals like solicitors, accountants, because they feel more comfortable having a professional dealing with it, making sure that it's done correctly, avoiding any kind of potential disputes within families. So, you know, some people, though, families, they live different parts of the country, different parts of the world even, so it's not necessarily practical for them to be dealing with the estate. So we say generally you shouldn't really name more than 4, because only 4 can go on the grant of probate, but actually you can name as many as you want to, but we generally say just name 4. And again, you can make it very flexible. You can cover what we call backup scenarios. So as if you can name your first executors and then cover off what if they pass away before you or they can't act for whatever reason. So you can really tailor it to whatever your circumstances are. Funeral wishes, very, very common for people to put these in just to make it black and white for the family what they want. It's not legally binding. That's the only thing we tend to point out to people. It is more of a guidance to the family. And I've seen pretty much everything in terms of funeral wishes. I've seen people knowing what being blasted into space and people being just put in a cardboard box and buried. You know, I've seen pretty much everything. So yeah, we see all the wacky and wonderful ideas that people have about funeral wishes. Guardianship, so this obviously tends to be in people with young families. They'll put a guardianship clause in there to cover obviously what happens if they pass away and the children are still quite young. Again, we recommend this to avoid potential problems, because I'm sure most people are aware different sides of the family don't necessarily get on, so it's always good to put in black and white what they'd want to happen, as unlikely as it would be to be needed. It's good just to cover it off. And again, sometimes we get people come to see us where maybe one parent no longer has parental responsibility for different reasons, so again, just covering off, making sure that that's if that situation did arise, you know, who's going to look after the children, making sure that they're not going to suffer any financial hardship as a result of being a guardian, all those different types of things. The next thing is just what we call specific gifts. So that sometimes is what we call a pecuniary legacy. So when somebody leaves a cash gift to somebody like a charity, friends, godchildren, that type of thing. And the one thing we point out to people with pecuniary legacies is that they come out of your estate first of all. So if somebody was to leave quite a large amount of money, we'd just warn them that if their estate does become depleted for whatever reason, they might just want to rethink that, because they could be less left in the pot for their kind of main beneficiaries, so to speak. And some people leave specific items, so it's, you know, sentimental pieces of jewellery, different contents in the property, leave them to named individuals, so that can be dealt with that way. There are alternatives to that as well. We can put a clause in a will which says that a person's going to deal with things under what's called a letter of wishes, so somebody can later down the line just compile a list of things and who they want to pass it on to. It just gives them that flexibility going forwards. And pets, obviously, pets are very important to people. So, you know, who is going to look after that pet if they pass away and the pet's still alive? You can keep it very general. You can cover potential pets in the future. You can name them. Again, lots of different options when it comes to animals. And finally, what we call the residue. So after all your different gifts come out, after your liabilities are paid out, so that's things like your funeral expenses, anything else like credit card bills, utility bills, they all come out of your pot first of all, and whatever is left over is what's called the residue of your estate. And again, that can be dealt with in a number of ways. You can just leave it to one person and then put a backup. So you often see that with spouses and children. They'll tend to leave everything to the surviving spouse on the first death and then to children. But again, you can do a number of different things. You can leave it into shares. So some people leave percentages to different individuals. Some people put a mixture of individuals and charities. So, you know, you can really tailor it to whatever your circumstances are. Yeah, if you just want to do a next slide, please, Chloe. So what other things can you cover in your will? We get a lot of different queries come through the door. Care fees is one that comes up quite a lot recently, and obviously it's quite topical at the moment with the proposed changes. There are different will structures that you can put in place that hopefully negates or at least takes into account some care fee planning. Inheritance tax, again, not a huge issue for a lot of people, but again, for some people, they do have taxable estates. So there are will structures that you can put in place to make sure that your estate can be dealt with as tax efficiently as possible, which I'm sure Sean will probably kind of cover slightly later. And vulnerable beneficiaries, so this can cover a variety of different issues. So vulnerable beneficiaries can include young people, so they're not necessarily mature enough to get money at 18. People might want to leave money till they're a bit older, like 21, 25, and they might not be very good with money. They might be going through personal problems. Marital problems are a common issue that people raise, so they don't necessarily want to exclude their family member, but they want to make sure the money's safeguarded if that person does enter into marital difficulties, and making sure that money doesn't get taken into account for divorce proceedings. Disabled beneficiaries as well. So some people are in receipt of means tested benefits, so they don't necessarily want to leave money to that person to affect their benefit situation. Will structures can be done to safeguard that and make sure the person's still taken care of, but still allowing some planning to take place so that they're not negatively affected by receiving money outright. And finally, divorce. We get a lot of people come to see us at the early stages of the divorce. So until that decree absolute is granted, if they don't put a will in place, technically that their soon-to-be ex-spouse would receive the estate. So there's lots of different planning you can put in place to make sure that that's obviously prevented. And if for whatever reason they were going to make a claim against the estate, if that was to happen, again, there's different will structures we can put in place to allow the executors to negotiate with that person, just to prevent court proceedings, really, just to keep the costs and everything to a minimum as it can do if it goes to court. Next slide, please. So what if somebody already has a will? I mean, we say a rule of thumb when somebody signs the will, we'll say get that will out about every 3 or 5 years, because you will be surprised how much changes during that period. You might put of people in that will as your executors that they may have died, you might have lost contact with people, and your beneficiary circumstances might change. People start to have grandchildren and want to obviously provide for them in the wills, for example. So much can change in a short period of time. It's always good just to keep an eye on what have you done. Do we need to have a conversation with somebody? And again, other things that might impact on someone's position is they might have made a will at a point where maybe they didn't have a large estate. They might have changed their employment situation. They might have received an inheritance from a family member, which can completely alter their inheritance tax position. It's always good just to keep in the back of your mind as things change throughout your life. Do we need to have a look at the will? Do we need to address this? And again, another point, a lot of people don't realise that when someone's made a will, if they go on and marry somebody, that marriage will revoke the will unless a clause is put in the actual will. So it's really important, really big life events. Always think, do I need to readdress the will? Next slide, please, Chloe. Homemade wills, we do sometimes get people come through the door saying, my mum's made a homemade will, or I'm thinking of doing a homemade will. Legally, they're absolutely fine. There's nothing wrong with you making a homemade will, but they're fraught with problems. People don't realise actually how complex will drafting is. Just something that on the face of it might look like it would deal with everything, it can create so many problems. It's not necessarily even just what you put in the will, it's what you don't necessarily put in the will. So our wills, for example, include different administrative clauses, which you don't often see in homemade wills, and those administrative clauses can prevent a massive amount of issues that can arise, such as, again, what if you've left money to a charity and they've amalgamated with somebody? What if you're leaving money to a beneficiary and you say they want to be 21 but they might need some money earlier? All different scenarios that aren't necessarily dealt with under homemade wills. That's why it's always important just to get specialist advice. And a lot of people don't realise, these will packs that you tend to get from these organisations, the difference in price between that and what a solicitor would charge isn't actually a huge amount. People don't realise we charge £150 for a simple will and £240 for a couple. So when you kind of compare that with these will packs, which sometimes they're about £50, you're not paying that much more to make sure it's done correctly. So we just say don't take the risk. It's not worth it. Of such an important document, pay a bit more money, make sure it's done correctly, and all your different issues that are addressed. And a lot of people, they come through the door and we raise a lot of different issues that they would never have even thought about. Common examples are, what if your children pass away before you? People don't want to think about that, so it doesn't tend to crop up on the radar. We talk through the different things that might occur if they don't address it in the will. So it's why it's so important to get specialist advice over something so important. Next slide, please. So yeah, I've pretty much just covered what I was saying. It is one of the most important documents that you will make throughout your life. And it's one that it's something to always keep in the back of your mind, as I've said, just to change because circumstances change. Always think big life events, grandchildren being born, new properties, coming into money, all these big life events should really automatically make you think, do I need to readdress my will? Do I need to think about things? Next slide, please. So next, I just want to go on to talk about lasting powers of attorney. So for anybody who doesn't know what lasting power of attorney is, if you think a will deal with things, obviously, when you're no longer here, a lasting power of attorney is a document that you put in place to cover what happens if I lose capacity? What if I can't deal with my affairs anymore? And it can be for a variety of different reasons. It doesn't necessarily have to be mental capacity. It can be physical capacity. So there's so many different scenarios where a lasting power of attorney is so important. And people don't realise that just because you're somebody's spouse or somebody's child, you haven't got any automatic right to start acting for somebody. It doesn't matter what your relationship is to that person. You need legal authority by way of a lasting power of attorney to be able to do things. Next slide, please. So there are two different types of lasting powers of attorney. One's called the property and financial affairs power of attorney, and the other is the health and welfare power of attorney. Next slide, please. So the property and financial affairs power of attorney, you probably can guess from the title, it basically covers everything in terms of your money, in terms of your assets. So again, for example, buying and selling property, accessing bank accounts, dealing with pensions, investing money, dealing with utility companies. People don't realise it's not just dealing with money, it's just your day-to-day affairs. What if your mum, sadly she started to lose capacity and maybe she's getting all these phone calls trying to sell her things, cancelling things on her account, again, dealing with utility companies, just your day-to-day management. Unless you've got that legal authority and you're not named on the account, they simply won't speak to you. And it can cause such distress with the family when it's already a difficult time if somebody's starting to show signs of dementia, Alzheimer's. You've got that peace of mind to know that if that does happen, you're covered, you can start acting for somebody, or somebody can start acting for you if you're in that situation. Another thing a lot of people don't realise, people with business interests. So we always recommend anybody that comes to with a commercial interest, they think about doing what we call it a business power of attorney, but it really is just it is just a lasting power of attorney for property and financial affairs. But people don't realise you can make more than one. So somebody with a business interest, they could come and say, well, I'll put one in place for my personal affairs, I'll name my spouse and my children. But you can actually do a separate one that deals specifically with your business interests. So you can tailor that document to say, that is limited to your assets in this particular company, and you can name anybody you want to deal with that. So people generally will might name their accountant, another member in the business to be able to do things, because it just takes one thing. They might go into hospital temporarily. Who's going to sign checks? Who's going to be able to deal with the business? It can really negatively impact on somebody's business if they haven't got that side of things sorted and they've got somebody to take over acting. So it can cause so many issues. And again, you can really tailor these documents to what your circumstances are. So if you don't feel comfortable with a person doing a certain action, you can restrict what powers they've got. You can say it's limited to certain actions, to certain assets, certain transactions. So you can really tailor it to whatever your circumstances are. We say generally attorneys should keep records of the spending, so what they're doing. They're not necessarily monitored like what a deputyship has to deal with, which I'll cover a bit later. But we say it's always good just to keep records in case somebody does, come knocking, shall we say, just to challenge what that person's doing. So keeping accurate records is important to a point, and keeping things separate from their own assets is important as well. And again, just lastly, what people don't realise is just because you've put it in place doesn't necessarily mean it can't be revoked. So if for whatever reason somebody wasn't necessarily happy with what the attorney was doing, or they thought that person was no longer appropriate, they can revoke the power of attorney whenever they want to. But the only condition is they have to have capacity to do it. So if somebody's lost mental capacity at that time, sadly it's too late. There'd have to be certain court applications made by different individuals, but yeah, it wouldn't be impossible. Next slide, please. So the health and welfare power of attorney, so not quite as popular as the financial one, but they are becoming more and more popular. I think particularly as a result of the pandemic, people have realised there's so many issues that have arisen as a result of not being able to, speak to people like care homes, social services, doctors. So people generally tend to put these in place when they've got quite specific wishes about what we call life-sustaining treatment. So that tends to be somebody, they're in hospital, they're on a life support machine. A conversation has to be take place as to whether that treatment's kept ongoing or whether it's withdrawn. The default position by law without a power of attorney is that the doctor would make that final decision. But a lot of people, for obvious reasons, they would want that family member to make that decision for them, because more often than not, people know what their family know what their wishes would be if they were in that situation. So anybody with quite strong views about life-sustaining treatment, really important to get a health and welfare power of attorney. But again, it does cover other things such as day-to-day matters, such as what the person's diet would be, what the daily routine is, what medication they might be in receipt of, what care home they would be living in, all sorts of different issues that can arise. And I say it's really important just to be able to get information. What if that family member is in hospital? The doctor by law doesn't necessarily have to divulge anything. Without that legal authority, they would be within their right to turn around and say, I'm not telling you anything, or you don't have any sway over what we're going to do. Getting that legal authority in place just prevents any additional stress that would already be in a difficult situation. And it does happen. We've seen cases happen during the pandemic where people have been trying to take the family out of the care home to be with them during obviously the lockdowns, and because they didn't have the power of attorney in place, social services effectively overruled them and said, well, no, you don't have any power to do that. And it created all sorts of problems and all sorts of stress for the family. But sadly, that's the legal position. So, really, really important. Next slide, please, Chloe. So enduring powers of attorney, you sometimes find clients have made these prior to 2007. So these were replaced by lasting powers of attorney in 2007. They effectively do the same thing as a lasting power of attorney, but there are some quite significant differences. So one important point to note about enduring powers of attorney is that they're limited to financial affairs. There wasn't the health and welfare aspect available at the time, so this was introduced in 2007. They're perfectly valid, they do exactly the same thing. The only main issues that we tend to advise people about with enduring powers of attorney is the registration process. So with a lasting power of attorney, what clients tend to do is they sign it and they get it registered straight away. So that means that document could effectively be used tomorrow, as soon as it comes back from the registration and from the Office of the Public Guardian when it's registered. Enduring powers of attorney is slightly different. They don't actually have to be registered until what's called the donor starts to lose capacity or has lost capacity. Now, the downside with that is that the registration process takes about 8 weeks. So during that period when you're probably going to need it most, you're going to be waiting about 8 weeks for it to come back from the Office of the Public Guardian. So we generally tend to say to people, if you have got one, it's fine, but you might want to think about updating it for that reason, just to make sure that it's all done, ready to go should the worst happen. And there's also other factors that you tend to find with enduring powers of attorney. So we tend to put different clauses in lasting powers of attorney, dealing with things such as what if the attorney needs to go and get financial advice. Some financial advisors don't necessarily take instructions from attorneys without specific clauses in there. There's other things that we tend to recommend, such as being able to access your will. What if your family needs to see what you've put in your will before they start taking certain actions and, dealing with certain assets. They can encounter so many problems if it's not dealt with. So we generally say they're fine, but you might want to think about updating it for A, B, C, and D. So, next slide, please. So general powers of attorney, these are powers of attorney that tend to be used for specific transactions and for limited periods. You tend to find it when you have somebody that maybe lives in a different country and they might have a house, for example, in England that needs to be sold. They don't necessarily want to come over and do the paperwork. They'll appoint somebody to sign the paperwork on their behalf. We do sometimes see them in other situations. So, for example, we do have criminal clients, for example, they might be going into prison for a short period, have somebody there to be obviously step in and do certain things for them whilst they're obviously when they're in prison. The only problem is that they are limited, so they tend to expire after a certain period, which is usually about 12 months, and they're only valid while the person has capacity. So if somebody puts one in place and then loses mental capacity, that authority then ends. So they're good for temporary things, for short-term things, specific transactions, but for long-term planning, not really the best. But people sometimes it's convenient for them, and the process is slightly easier than a power of attorney. You don't have to get it registered. You can just sign it, have it witnessed, and legally it can be used. So specifically, they can be good for certain individuals, but not for a long-term planning situation. Next slide, please. So deputyship, I touched on this earlier. So a deputyship order, this tends to be used for people who they've lost capacity, but they haven't put a power of attorney in place, a lasting power of attorney specifically. So if that person loses capacity and then somebody has to start acting for them, be it things like sell the house, access bank accounts, they have to make an application to what's called the Court of Protection. So they are then appointed by the court as what's called that person's deputy. Now, they still have the same authority as an attorney, so they can do exactly the same things. So again, selling houses, accessing bank accounts, dealing with pensions. The downside is a number of things. So one is the application process. Compared to a lasting power of attorney, the amount of forms you've got to fill in it's huge. You've got to fill in all sorts of different forms, such as reporting that person's financial situation. You've got to get a capacity assessment from a doctor confirming that person doesn't have capacity. And then the process itself takes about 6 months from start to finish, because the whole process involves the court issuing applications. They require you to serve the application on what are called interested parties. So you've got to involve other people in the process, and basically just to prevent kind of abuse and people being taken advantage of. And when the actual application process is near completion, you have to do things like what's called put a security bond in place. So this is effectively an insurance of that person's assets, just in case the deputy goes off and misuses the funds or something goes wrong. And then on top of that, there's ongoing responsibilities that the deputy has. So compared to an attorney, where I said obviously you're not compelled to keep records, you are really heavily supervised by the Court of Protection as a deputy. So every single year, they send you an account form to fill in. So you have to fill in this form outlining everything you've done for that person during that year. So all the spending you've made on their behalf, everything from start to finish. And it's incredibly cumbersome. If somebody's got their own life to deal with and, they're looking after this person who maybe's lost capacity, it's a very, very stressful thing to have to do and a huge amount of responsibility. And on top of that, you've got to pay the Court of Protection for the privilege of actually them supervising you as the deputy. So not only is it a very lengthy process, a very costly process and stressful, there's all these ongoing responsibilities and costs you've got to pay on top of it. So we generally say, if you've got the family members there that you would feel comfortable being your attorney, get it done. You don't want your family have to go through this, particularly when they're dealing with a friend or a family member who might be starting to lose capacity. Having to go through this process on top of it just adds more difficulty, more upset to an already difficult time. So we say, if you want to avoid it, get a power of attorney in place. Nobody wants to lose capacity. Nobody wants these things to happen. But I try and get people to think of it like an insurance policy. We take out insurance on our houses, our cars. We don't necessarily want bad things to happen, but they're there to cover the what ifs. So powers of attorney are exactly the same. We don't want to lose capacity. We don't want to end up in a care home, but we have to face facts that sadly statistics are against us. If it's not a mental issue that's going to affect us even just temporarily, it could be a physical one. So getting this in place, it just covers the what ifs. And what I try to say, it's a document you have to put in place, but it's not actually you that sees the benefit of it, because it's really just for the peace of mind for your family to make sure that if the worst happens, you've got your ducks in a row, you've covered everything off, and you're going to make life as easy as possible for them if the worst happens. So that's really all it comes down to. Just the last slide, please, Chloe. Yeah, so I've just obviously covered that off, that it just causes so many problems if people don't have powers of attorney. We tend to talk about them as a side note, and that side note when somebody comes to see us about wills, you know, you're getting things in order for obviously when you're no longer here, but it's always good to think about what if you are here but the worst happens. So they really do go hand in hand, and it's a no-brainer really. So that's it. So obviously if anybody has any questions, I think we're taking those at the end. Happy to speak to anybody one-to-one or answer any questions that anybody might have.
Thank you, Lindsay. Really useful. Thank you.
Yeah, thanks, Lindsay. Given what's going on at the moment, have you seen more and more people looking, you know, getting on the entry level for wills and lasting power of attorneys? Have you just seen that increase?
Yeah, absolutely. I mean, we kind of got, I'd say we got inundated with things, particularly at the start of the pandemic, but to be honest, it hasn't really slowed down. I think the past 18 months have really made people think about their own mortality and know that, you know, it doesn't matter how old you are and how fit you are, you know, it just takes one thing to sadly get you, and you know, it can put you out of action for months, can't it? You know, and if you don't have your affairs in order, who's going to pick up the pieces? So yeah, I think it's certainly focused people's minds, that's for sure. Yeah,
we're seeing that as well on our angle, I guess. So that probably leads on to me and my little slot. So if you can run the slides, Chloe, thank you. Yeah, so I guess my angle, it will be a taxation angle from both the planning and the will side of it. So as Chloe's put on the slides, there's probably 3 items to consider. First is the allowances that will be available. Then there's a couple of some tax efficient items you can look at, and then it's just a bit of a key point as to where you go from here. So if you can go to the next slide, please, Chloe. To start off with, really, is why do you look at inheritance tax planning? Well, as you can see from that very famous quote from Benjamin Franklin, there's nothing in this world, nothing can be certain except death and taxes. And unfortunately, with death, depending on the size of your estate, there will be tax, and that's normally left on your beneficiaries to bear the cost of it. Taxable estate, as Lindsay highlighted in her slides, is really all your assets that you own, less any liabilities, which is then subject to tax, and tax is at 40%. However, there are some allowances, as I'll just talk through in a moment, which will reduce your taxable estate in order to minimise any sort of taxation that you'll pay. So what I will say is that currently these are all in place at the moment. There's an office in HMRC that is called the Office of Tax Simplification, which strikes fear into a lot of our hearts when they say they're going to simplify tax, which generally means they're going to do something which might mean you may pay more tax. So what I'll say, caveat what I'm saying now is that these are the things that are in place now. They may change, probably not for the next couple of years, but just to be wary that if we're looking at tax planning opportunities now, it's probably the time to look while these allowances are in place. So you see you've got your first allowance, which is the 325,000 amount, which is called the nil rate band. So this is the amount that you can have in your estate without paying any tax. As you can see on the slide, you can share that with your spouse, civil partner, and if you don't use that amount, you can transfer it across. So as well as you having that, if you're married or you've got a civil partnership, your partner gets the 325 as well. The second allowance to take into account is the residence allowance, which is based on your home. So again, that allowance is £175,000, which again will mean there's no tax paid on that level. And again, that is also shared with a spouse and civil partner. Either you can use the unused amount and they also get that amount. So you can see £500,000 is what you can have as a nil rate band, and the same for your partner. So it's your spouse or your civil partner. So you see that it could be up to £1 million of joint assets that you have that don't fall within IHT, which is quite a substantial figure. But obviously there are people with estates that are bigger than that. So, and a couple little planning tips. There are some allowances that you can utilise even before you look at doing a will. So there's an annual allowance, so you can give away £3,000 worth of cash to somebody. It's £6,000. If you don't use the £3,000 in a year, you can do 2 years in one go. You can make what's called small gift allowances. So that's £250 to each person. You can have multiple people, but as long as you haven't gifted them anything else in the annual allowance or anything else, you can do that. And then you've got the wedding gift. You can give £5,000 to your direct child, £2,500 to your grandchildren, or you can actually give £1,000 to a relative stranger to marry. So that all comes out of your estate. So you're allowed to gift those items out of cash without having any penalty. And the last bit is something that's called normal expenditure out of income. You're allowed to gift money from your estate if it would normally not would be normal part of your everyday living. So as long as you're not compromising your cash flow or you're not stretching your resources to the bone, you can give that cash away and it doesn't get caught in any sort of tax trap. So those are the general allowances that you can use. So if you go on to the next slide, please, Chloe. These are a list of the more tax efficient items that you can have in your estate. So again, the political and charitable donations are free from inheritance tax, so you can gift those as well. And then you have what's called a pet. So not the pet that Lindsay talks about in the wishes, looking after your cat or dog. These are called potentially exempt transfers. So what this means is that you can actually gift anything out of your estate for it to try and minimise your tax. Now this comes with two sort of caveats, two things that may cause that to cause you some problem. First of all, it's called the 7-year rule. So if you gift an asset out of your estate, you basically start a clock ticking, and then you've got 7 years. You've got 7 years for that to be fully removed from your estate. If you don't unfortunately live those 7 years, then you've got a timeline from when you gifted it to when you die, and depending on how long you've lived along those 7 years, your estate or whoever you gifted it to will pay tax depending on the length of time. So it's called taper relief. So for example, if you only lived between 0 and 3 years after you gifted, you would pay tax at the full 40%. 3 to 4 years, it's reduces to 32, 45, 24%, 5 to 6, 16%, 6 to 7 is 8%, and then after 7 years, that's when it falls out of your estate. So some people do look at making gifts prior to them dying. And the second rule is what you've got to, second caveat is what you've got to figure in. If you're gifting away an asset that's increased in value, you could be subject to capital gains tax. So although you'll remove it from your estate, there could be a tax that you're triggering, depending on whether that value of your asset has increased. The capital gains threshold is £12,300 worth of gain. So for example, say you had an asset that cost £10,000 but is now valued at £25,000, you would pay tax on the difference after the 12,000. So you pay tax on round about £3,000. So you've got to be careful when you're gifting out assets. People normally look at assets that you call appreciating assets, so that assets that are growing in value year on year, to maybe look at gifting, as that can save you tax in the outcome, in the long run. Sorry. So the second thing to look at is your home. So with everybody's home, the default position, as you can see there, is joint tenants. So that means if you die, there's an automatic transfer to your spouse, but you can actually build in your will a tenancy in common, which is worth pursuing, because rather than an automatic transfer, it means you both own a certain percentage of the home. So therefore you can have more flexibility in how you use the gifting of that, or the passing of that share of the house, which can have a lot of benefits for both taxation and for care purposes, as Lindsay highlighted in her section. So one of the most tax efficient assets you can hold is your pension. So what you can do is put money in your pension, and that is removed from your estate. Obviously, what you've got to consider if you're looking at putting money in your pension is that's tying up your income. So you can't actually get hold of that income. So you've got to be really careful when you're looking at pensions. Although it's really efficient for inheritance tax, you've got to make sure that you've still got your living expenses while you're still alive. So you can consider other investments on top of your pensions if you're going to look at putting money away to save inheritance tax. Things like ISAs are a really good one. They're tax efficient vehicles where you can still draw the income, but you won't get taxed on an income tax side of it, while still maintaining a healthy pension pot, which will protect some of your inheritance tax liability. And then the last one on this slide would be trusts and discounted trusts. Now, these are quite complex, so I'm not going to go into detail. This is probably another webinar, but you can use trusts where you move out assets or cash from your estate into a trust or a discounted trust, which again gives high IHT relief and also gives control of your assets after you've gone, in case there's things like marital disputes or there's a second marriages, or really if you want to protect the people that you're gifting money to make sure that they don't take your gift and buy a fancy sports car rather than using it to pay out of their living expenses or setting themselves up in a home. Next slide, please, Chloe. So one of the other things to consider as well is looking at life insurance. So life assurance. Life assurance can be written policies written in trust. So these can be used to either meet or reduce your inheritance tax position. You need something that's called whole of the life policy. Obviously, that means it covers the whole of your life. So looking at life assurance is a really good way of not only reducing inheritance tax, but also protecting your beneficiaries in order to cover any inheritance tax liabilities that you leave. Also looking at shares, particularly the alternative investment market called AIM and enterprise investment schemes, EIS shares. Both of these are really tax efficient vehicles. They're taken out of your estate as long as you've owned them for more than 2 years. So you can save a lot of inheritance tax by putting your money into those sort of investments. But what you've also got to consider, there is a risk attached to both of these because these are based on shares in the stock markets, and obviously can be very volatile. If you've seen what's happened to the stock market over the last 18-24 months, it is quite a volatile position. But so you've got to look at really the trade-off, inheritance tax versus do I preserve the capital that I've got. So one of the other areas to look at that are really tax efficient is business property relief. Now, this relief is given to any assets that are to do with business, as the name suggests. They're outside your estate or at a reduced rate, set into subject rules. As you'll see above, I've mentioned AIM and EIS shares. As long as you hold them for 2 years, they are totally moved out of your estate. If you've got shares in a private trading company, they are 100% outside of your estate as long as you cover certain rules off. And assets used in a business partnership, you will get 50% of those will be reduced from your estate. So having any assets in that sort of categories, again, are really tax efficient ways to minimize any inheritance tax that you're going to pay. And then the kind of last thing on this slide is you can actually reduce your tax inheritance tax rate from 40% to 36%. In order to do that, you've got to give a legacy to a charity within your estate. Within your will. The legacy has to be more than 10% of what's called a baseline amount of your estate, which is effectively your taxable estate plus the charitable legacy. So if you make that sort of bequest, you can actually reduce the rate of tax from about 10%. Obviously, it doesn't have to be all your estate given to the Cats League or RNLI, but you can do a proportion to do it in order to reduce your tax. Next slide, please, Chloe. I almost tried to click on the button there myself. So I mean, that is a whistle-stop tour of the allowances and some of the tax-efficient vehicles that are available that you can utilise. As also Lindsay said, that if anyone wants a more complex chat, we're all here to have a discussion either here or afterwards, or you can email us. But just the items to consider is if you haven't started, is start now. Although it's a morbid subject, it's really something that you need to consider as soon as possible. And as Lindsay mentioned, to review frequently, every 3 years, every 3 to 5 years, looking at what's in your estate and what you can do is vital, really, if you want to plan effectively and leave as much as you can for your descendants. So one of the things we always tell our clients to do is make a list of your assets and liabilities and kind of do a rule of thumb or a quick calculation to see where you sit in terms of IHT, and then you can start looking at what you can do to maybe minimize that side. But remember, you need to remember to consider the income now. While you're living, it's all right protecting yourself for your death. You've got to make sure you've got your income needs covered for while you're living. So again, it's a trade-off. Putting some cash in an asset that's going to save you some tax, but make sure that you have got some money to live on while you're still alive. We would call it, an IHT versus tax trade-off. You've got to protect some investments, so you're ring fencing your cash, but you just got to make sure you don't really sell yourself short. And basically, the last bit is know what you want. What do you want to achieve, and how do you want to achieve it? It's got to reflect your wishes and protect your assets. And I can't emphasise the business side from my side. The business side of the LPAs are really key. You can see some horror stories where, unfortunately, people have been in accidents and they've been the sole director, and without an LPA on the financial side, you're putting people's jobs at risk because you can't access anything. It's really something key to consider if you're in business and you're a shareholder or a director, to look at these sort of areas. I think that's it. Last slide, Chloe, please. Yeah, as I say, it's something. The keys to it are look at what you need, look at what you've got, and then discuss it with your advisor, and then start implementing steps as soon as possible. And if you've got something in place, then review. So thank you. That's me. So there's my contact details on the screen. I think we've just about got to the Q&A side of it. So I think we'll just open the floor to any questions that people have got that we can help you with in the next 15 minutes.
Yeah, thank you, Sean. Thank you, Lindsay. Yes, as Sean said, we've got around 15 minutes left. So if anyone's got any questions, pop them in the chat box or the Q&A box. I do have one from before, from a client for probably Lindsay. How long does it take to prepare and finalise a will?
Well, it depends on the client. I mean, I would say on average, most people tend to, from start to finish, it's usually about a 2-week process. A lot of it depends on, if they want to go away and think about it, or, if they've got issues that they maybe want to come back to me on. So, we're maybe having a conversation about the tax position. They might need to go away and get some information for us before we can advise. I'd say generally for 99% of people, it's on average about a 2-week process.
Yeah, thank you.
I've got one for Lindsay as well, if that's all right. Don't worry.
Yeah,
Lindsay, it's not hard. Deed of variations, do you normally deal with those as well?
Yeah, absolutely. They're quite common now. I mean, I don't know if anybody's aware what deeds of variation are. They're when somebody wants to vary an entitlement that they get from an estate. So they get X amount of money, or they're a residuary beneficiary from an estate. They might want to vary that entitlement. So sometimes somebody might receive an inheritance, but for whatever reason, they might have a taxable estate, so they don't want to obviously bump that up even further. They can divert where they want to send that interest on. So they might say, well, I'll bypass me and give it to the grandchildren, and because basically as long as they do it within 2 years of the date of death, it's deemed that it was effectively written back into that person's will. So as Sean alluded to, a pet, it wouldn't be classed as a pet, so you wouldn't have to survive the 7 years or anything. So yeah, they're becoming more and more common, to be honest.
Yeah, I've seen a few, and I think it's principally the ones I've seen have either been to increase the charitable donations, so they're reducing the tax, and also I've seen people look at maybe giving the particular business property relief assets instead to the spouse to other people, so not using that allowance.
Yeah, absolutely.
There's loads of things.
Yeah, I've got one for you, Sean. Kind of just touching on this. I'm sure the answer's probably no, maybe it's too soon, but are you finding kind of any queries as a result of the national insurance hike? People kind of altering, what they're doing in terms of their own kind of income tax position, for example, as a result to try and even things out, or is it not really?
That's a really good question. I think not yet, but I think it is a bit early. But with the dividends going up and national insurance going up, I think you might see more and more people looking at it and looking at things to really change what they're doing and how they're moving the money about. So I think the answer not as yet, but I'm pretty sure that might start the ball rolling.
Yeah.
Any more questions from anybody else? As I say, there's the chat box and the Q&A box to put them in. If you haven't, that's fine. If you think of something afterwards, as both Sean and Lindsay have said, just contact them and they can either book a one-to-one or just an email or whatever. If there's no questions, then we'll maybe wrap it up, if that's okay. So that's the end of the slide. Let me just check if there's not any questions at all. Not that I can see. It's okay. Okay, that's fine. So thank you for everyone for coming today, obviously joining our webinar. We really hope you found it useful. Like we've said, it's a morbid subject, but it is important. If you, as I've said, if you want to contact us, we are here afterwards, on email, phone call, and you will be tomorrow getting a recording of a link to the recording of this, because it'll go onto our YouTube channel tomorrow. So if you have missed it, then it's not a problem. You can rewatch it and look back on it. We hope we've done well for our webinar back after 2 months. I felt like Boris Johnson. Next slide, please, Chloe. But yeah, our next webinar will be in October with the topic to be confirmed. So look out for what that's going to be about on social media and the website, etc. I think that is everything. There's nothing I can see in the questions.
No, just I'd like to thank Lindsay for guesting on this. It's a really hot topic. All the things that I've seen from what's coming out from the pandemic is the gap between the old and the young is squeezing. So looking at your inheritance tax position is quite prevalent now. People's estates have been dwindling away. So it's what you can do to stop tax really taking another big bite out of your estate, so that you can leave it to your children or even your grandchildren. Looking at moving things from, instead of gifting to your children, moving on to your grandchildren is also a really good planning point to look at as well. So there's loads of things to digest, but thanks for attending. Our attendees, you've made the first step if you have not considered a role before, so that's great. So thank you.
Yeah, thank you very much. Thanks for inviting me on.
That's okay. Thank you, Lindsay.
Thank you.
Thanks, everyone.
See you all later.
Bye.
Bye.
Yeah.